Every single wedding actually functions as a precise legal contract, requiring flawless execution to carry any weight in court. For a family law practitioner, establishing the legal validity of a marriage is the prerequisite for all subsequent advice. Before addressing assets or status, you must prove the marriage actually exists in the eyes of the law. The primary authority for these requirements is found in the Marriage Acts 1949 to 2019. These statutes dictate the exact conditions necessary for a union to be recognized. Without proof of a valid formation, a practitioner cannot proceed with divorce proceedings or financial remedy applications. The underlying legal foundation must be absolutely verified before any part of the relationship can be successfully litigated. Validating a marriage in England and Wales depends on the couple's adherence to preliminary formalities before the ceremony occurs. Most ceremonies require a standard civil notice filed at a district registry office. However, marriages within the Church of England or the Church in Wales follow a separate statutory pathway that bypasses the civil registry. Understanding this Anglican track requires looking at specific legal mechanics and the procedural errors that can invalidate the entire union. Professionals must distinguish between these tracks to ensure a correct assessment of a client's marital status. The first essential requirement in the Church of England pathway is the publication of banns. The banns are a mandated public announcement made in the parish church where the wedding will occur, and usually where the parties reside. In this specific context, the banns serve as a complete substitute for the standard civil notice required at a registry office. Chronology is critical here. The marriage notice cannot be given more than 12 months before the ceremony date. Through this system, the state delegates preliminary legal vetting to the local parish, treating the public announcement as a sufficient check against legal impediments. This centuries-old system is modified when one or both parties are non-EEA nationals. To maintain the integrity of immigration laws, the standard religious pathway is redirected. These couples must comply with the religious publication of banns while also filing a civil notice at a district registry office. This requirement allows the Marriage Referral and Assessment Unit, or MRAU, to screen the application and extend the notice period if an investigation is required. This shows that statutory requirements for national border security take precedence over religious exemptions. The ceremony itself serves as the final stage of binding legal formation. Beyond its religious significance, the event must meet 3 statutory parameters to be valid. It must be celebrated by an authorized Church of England priest. It must follow the authorized form of service, and it requires at least 2 witnesses. If these 3 parameters are not met, the ceremony fails to create a recognized legal union, regardless of its spiritual intent. What is the consequence if any of these preliminary or ceremonial steps are missed? Section 25 of the Marriage Act 1949 identifies specific failures that render an Anglican marriage void. First is the failure to carry out preliminaries, like omitting the banns. Second is celebrating the marriage in a church different from the one specified. Defects also occur if the ceremony takes place after the 12-month notice has expired, or in defiance of a formal parental objection. In these cases, the law voids the contract. However, these defects only invalidate the marriage if the parties knowingly and willfully disregarded the requirements. While the law accommodates accidental errors, intentional circumvention of the procedure results in a marriage that does not legally exist. When Section 25 is triggered by intentional noncompliance, the marriage is considered void ab initio, void from the very beginning. Successful publication and an authorized ceremony result in a valid marriage. Procedural breaches lead to nullity. This is distinct from divorce. A Section 25 failure means the marriage technically never existed as a legal entity. This status fundamentally alters the court's approach to financial remedies and property division, as the parties lack the protections of a legal spouse. Verifying the procedural history of a wedding is the prerequisite for securing a client's legal and financial future.